you have to be very specific. So please, we will have Sanchez v. State. That's 165 Southwest 3rd, 707.
Yeah, it's from 2005. And both these are Court of Criminal Appeals cases.
So we'll have that in there, but you have to be very specific on how you preserve error in that situation.
Yeah, it's 4 points. It's a 4-point deal.
Yeah.
Exhaust your peremptory challenges, request more, your request is denied, and then you identify the objectionable person. In this case, I'm just using juror number 7 for lack of another
we always say juror number 7.
Always?
I don't know. I just made that up.
Okay.
Yeah, that's a good case. That's a good case to have. We will include both of these cases, citations, in the show notes, and I'm going to try and put a Dropbox link on the show notes as well so that they can just access them.
Wow.
We've done that before in the past. If you could locate them, you would know that.
I'm still trying to find the jury notes. The show notes, not the jury notes.
Show notes. The show notes are important. I think show notes are only on our Apple Podcast listeners.
Maybe.
Spotify as well.
I don't know.
When are you picking your next jury?
It could have been as early as Friday, but I found out that the state, the SANE exam nurse is on medical leave through at least the end of May.
Okay.
So that case has been pushed.
Sounds like a continuance to me.
Yeah, I've already talked to the prosecutor, and I said I'm not going to object. I understand it's our first trial setting. His mom actually talked to me this morning and said, how do we know it's, and I said, look, some of this is not the judge is going to give it to him.
Right.
And if we say, Judge, it's the state's continuance, I don't have any objection.
If we need one later.
Right. And it's a prosecutor I know. He emailed me something. I called him and he goes, even from when I emailed you, this changed. And I said, hey, I get it. And I know that if I need one later, you're going to say, of course. He goes, yeah, of course. Right? I mean, part of it is somebody I trust, and they're going to trust me if I say, hey, I've got a witness that needs to be here and can't be.
Do you have any other cases you want to talk about today on this show?
No, those are the 2 cases that I've pulled since that jury selection in January.
Good.
And put it in my file, right? I mean, it ate at me. I don't know that it made a difference. But knowing that on that 3-count sexual assault, using my method, I guess I should copyright it.
Sure.
Because
write a book. We'll talk. Yeah.
Yeah. Anyway, my method on beyond clear and convincing evidence that the trier of fact has a firm belief or conviction, and when I'm teaching it, I'll just go, now look, y'all all know I was a former pastor, and I'm about to go to preaching. I mean, I just flat go into it. I mean, I know my cadence changes, my voice changes. I mean, I feel that like I'm about to throw down some stuff.
Sure.
And knowing that on that sexual assault case, 3-count, the women on the jury came back to me and said afterwards, the way you define beyond reasonable doubt, we couldn't get there. Right?
Yeah.
So that becomes huge on those. Where does it sit?
Right.
So
no, you're right.
Again, it didn't completely throw me. I did get to finish up, but I didn't feel like I had.
If for nothing else,
didn't have the swagger I normally have.
You may never. I mean, you probably will use these cases again. I mean, this stuff does come up, but it's almost like your safety net. Like you have them when you do have that situation again. You know how to reply. You know how to respond. That's why having these trial notebooks and trial binders are so effective, because there's like a huge comfort level for attorneys when they do have them, right? You've prepared, you've got your binder, everything you need is in there, all the case law. I mean, you can't question like every scenario. You can't predict every scenario, but having that in there is a big comfort blanket for you.
Yeah, it's knowing, again,
comfort blanket's a weird phrase, right. But it's like a safety net.
It's knowing that, if you, in opening statements or even in jury selection, especially like in the sexual assault of a child, if you start talking about mistake, right, you've just opened the door to them bringing in any other collateral sex assault cases. It's knowing when when the judge says move along, that you really do have a right to question that panel, to listen to that panel, especially on things for challenge, things that could be removable for cause or for bias. To know, Judge, the state doesn't get to bring this person back in and rehab them. And it's something I've actually talked about in the CLEs I've led. The judges that I've seen have really gotten good where the state will say, hey, we need to bring them in and try to rehab them. And the judge says, no.
Yeah.
I think enough of it in their CLEs, because the judges have them too, they've been told that's reversible error. You put somebody on there that said they have a bias.
Right.
And I almost busted a panel one time with just, would you be biased against him? And they said yes. And I was like, Judge, they said they were biased.
Right.
Right. And here's the deal. Most of us, if we really kind of get down into our heart and ask, am I biased against someone who's charged with a crime? Yeah, probably.
Yeah.
And the more heinous the crime, the more I'm like, yeah, I might be.
Depending on the situation and the charge and all that, absolutely.
Right, but it's hard if it's our job not to be and to fight for them. The average person is really going to have a hard time. Now it may not be in the front of their head bias. It may not be like I'm looking at this person and I don't like a guy wearing a blue coat.
Mm-hmm.
Right? It could be something much deeper, like I don't even remember having that teacher that yelled at me, but he kind of looks like that teacher that yelled at me in the third grade, and so I don't like him. I just know I don't like him, but am I biased? No, I'm not biased, but I don't like him.
It's like subconscious.
Mm-hmm. Yeah. I mean, it could be anything, but all of us have some bias, and then you add this person's been charged with delivering methamphetamines in a school zone. And people go, no, don't need drugs in our schools, don't need meth. Right, and it's really hard to kind of have that piece.
Yeah.
So really, what we were talking about on this jury selection piece is you have a right to question using civil law, the civil standards, not to define beyond a reasonable doubt, but to push that beyond a reasonable doubt as high as possible in the food chain.
I think the legislature kind of made the bet on that one when they removed the definition.
Yeah, in fact, so I do a lot of my thinking when I'm running, and a few days ago I actually thought, I don't ever want them to define beyond reasonable doubt, because if they do, it will never be as high as what I get them to.
Yeah, no, that's right. That's right.
So we'll talk about the Andrew method of establishing clear and convincing evidence
if your ego can handle it.
Well, I'll have to write the book first.
If I can handle your ego, I mean. What else on jury selection do you want to talk about?
I think for today that's going to cover it.
Yeah.
Really, be prepared to say, Judge, I have under the law and under case law a right to question the panel using the civil standards and to establish bias and to establish that they understand the law. Not just the way the state interpreted it, but the way I'm asking them to interpret it.
Yeah. Smart. We talked a couple episodes back about a jury trial that I had where it was a mistrial after the jury was sat because one of the jurors had been
on the social media.
I was in court yesterday to retry it, to pick another one, but we were back up to a civil jury. And so, it's just kind of one of those things like, I'm already prepped. We're just redoing it. And at 3 o'clock, the plaintiff's attorney, who's the first one to talk on a jury selection, still talking. And I'm like, Judge, I'm not picking a jury at 6 p.m. There's just no way. So everybody's hatred of homeowners associations had push our trial, give us a little bit more time here.
Does anyone who's a member of a homeowners, this is a poll for our group. Anyone who's a member of a homeowners association who's not on the board of said homeowners association, do you feel like you get the value out of that fee every year?
I do a little bit of real estate investing, right? A little bit, very small. I was looking to buy a condo in Fort Worth. Their homeowner association fees were $300 per month. Per month. Looking around at this complex, I could not fathom where $300 per month per unit was going. There was trash everywhere. The grass was overgrown. Paint was peeling. I mean,
are you talking about our office again?
We are not talking about your office. We at least have a decent slumlord here at this office.
Well, thank you.
But it was incredible. So yeah, HOAs I generally opposed. Although I do like it when my neighbors, abide by the restrictions.
Yeah. Well, Mr. Harris, you got anything else?
Nobody
We talked about the books we're reading and stuff like the last few sections.
Yeah, I don't have any new books or artists or advice for everybody.
Well, have we talked about the new Taylor Swift album on the show?
It's fire.
It's the darkness of it. I kind of like the darkness of it. And I'm not a Swiftie.
We need to get Deandra on the show,
right?
To talk
so
about it.
So our office mate Deandra took us to lunch on the Friday the album dropped. She wore a T-shirt. We had Thai food, and she was just giddy.
Yeah, she was excited.
I think we may have agreed to go to a Taylor Swift concert with her.
Oh, I've been to a Taylor Swift concert. They're incredible. She puts on a heck of a show.
So
absolutely.
If you see us,
I'm not spending thousands of dollars on the next Taylor show, but I have been, and they're incredible.
All right. So
you would love it.
I probably would. All right. So first of all, you can find us on Twitter, on Facebook, hopefully soon on Instagram,
on YouTube.
On YouTube. What the hell?
That's right.
So for Mr. Harris, I'm Mr. Decker.
And for Andrew Decker, I'm Andrew Harris.
I'll be good.